my dear friends. I am back with the medical legal tip number 3 and 4 today. So, the first tip, what I am going to tell is about the consent signatory. Mostly, my colleagues and even sometimes myself, we have made mistakes that in a hurry we feel that anybody can sign the consent. Only that consent has to be signed. That's what we feel. But let me tell you the two most common mistakes which are committed by surgeons while taking consent in India. Taking a general consent at the time of admission is fine, that is required, but general consent is not taken for surgery. For surgery, you have to take a specific informed written consent for surgery, explaining to the patient what you're going to do, what are the things to be removed, what are the organs to be touched or removed, what is the prognosis, what can be the failure rate, what is the success rate. All these has to be explained, and then a separate consent has to be taken in case and especially in cases where in cancer and all, if there is extra precaution to be taken and extra organs to be removed, then in that case you have to take a proper informed consent. Now, secondly, who are the signatories who can who can give consent for such things? First and foremost, I would like to say that patient is, if he is conscious and if he is able to understand everything, he is able to give his signature, then that is the first choice for consent signatory. Then comes the parents, then the spouse, then children, relatives of a conscious and stable adult. They are not valid. Okay, so if the patient gives consent, then it's fine. If the patient is not able to give consent, the patient is unconscious, or the patient is unable to understand or comprehend your information, in that case, then the two relatives have to be taken for consent and also as witness. This I'm telling you with in reference to National Consumer Commission case which happened. It is a very interesting case, Ram Gopal Varshney versus Laser Sight India Private Limited. One old man in this case, Ram Gopal Varshney, he underwent a cataract surgery and he lost vision. The consent was taken from his grandson. So what happened in this case was that the doctor was not taken for any negligence or other charges. They could not prove it against him, but he was held liable only for failure to take consent of the patient. So please remember, patient's consent is the most important. After that, if suppose you please write it on the case sheet that patient is unable to understand or comprehend or unconscious, and we have to take the consent of the relatives. In that also, the relatives in the preference order is the blood relatives are the most important. That means parents or wife or husband, that is the spouse. Then comes the brothers, sisters, and all, and then comes the immediate relatives, even if they are present, and so they have to be given, and then distant relatives, and then last comes the friends, and last of all, if there is nobody, none of them you can approach, then in that case the person who has brought the patient can give consent in such a situation, but two witnesses have to be there who can sign this, who can sign and say that they have witnessed this problem. Then, next I come to medical legal tip number 4, how to transfer the patient. Now, transferring the patient is a very, very important thing for not only pediatricians, as we transfer neonates, we transfer our pediatric patients. So, it is very important to understand that under the Clinical Establishment Act, a doctor should stabilize the condition of the patient before transferring the patient into another hospital. You must write on the case sheet the time and the vitals and what is the condition, what all is there on the patient, whether a ET tube has been put, what are the vitals at that time when you have dispatched the patient. All this has to be written. Now, Section 2D of the Act has defined emergency medical condition as a medical condition manifesting itself by acute symptoms of sufficient severity, including severe pain, of such a nature that the absence of immediate medical attention could reasonably be expected to result in three situations. It can result into placing the health of the individual For example, pregnant woman or her unborn child in serious jeopardy. That is one situation. Second, a medical condition is considered emergency if serious impairment to bodily function can happen if we do not transfer. Third, serious dysfunction of any organ or part of a body can happen if we do not transfer the patient. So, this is what we have to understand, that when we are transferring the patient, whether it's a really an emergency, and then only we can transfer. Secondly, we have to stabilize the patient and then transfer. So, thank you very much for listening to me. I hope these tips are useful to you. Thanks a lot, and we will